All right, hello, welcome back to Trial TV Live. I am the Squeegee of Justice. Let us pick up on part 2 of day 13. And thank you for joining us.
Back on the record in 231-500-139. Counselor present, Ms. Richins is present. Ms. Nestor, you've had an opportunity to confer with Ms. Richins. How does the defense want to proceed?
Thank you, Your Honor. Thank you for the break. We appreciated that. So we have reviewed the case. We clearly understand the court's ruling that if any of it comes in, all of it comes in. We get that. We also understand and appreciate that the court is going to require proper foundation, and we're not skipping any steps. We accept the state's representation in good faith that Officer O'Driscoll, he's out still, right? He is not the foundation witness because he is not the individual who communicated with Mr. Norris. And we will, if we proceed with this line of questioning and we decide to introduce this evidence, we will do it through the proper foundational witnesses, which we accept as not him. So to avoid confusion now, since it's not him, we will wait and not ask the questions that he doesn't have, because it's like you said, there's no way to ask the question without introducing the substance. We couldn't figure out how to do that. So we're going to wait until we have a foundational witness, and then we will proceed that way if we can lay a foundation.
Okay.
And if we decide to go forward with that evidence.
I appreciate that. If you make that ultimate decision,
we'll give everyone a heads up.
I appreciate that. And one of the reasons I would need that is to make sure I give defense an opportunity to state on the record, or at least summarize on the record, their strategic balancing of the risks and benefits so that there is a record of that going forward.
I appreciate that, and I think that's probably a good idea for everyone.
Okay, very
including
good.
Us.
So, Mr. Bloodworth, because the defense will not be opening the door to any portion of its incomplete investigation theory related to David Norris through Detective O'Driscoll, I don't believe the state would be permitted to respond to it yet. Is that your view of it?
That is my view of it, Your Honor.
Okay. So, as a matter of status quo, we are going to proceed with additional cross-examination of Detective O'Driscoll, correct?
Yes, sir.
Did we reach I'm sorry.
Could we just go ahead and, well, I can just do it through, I think we decided I would just ask him about 340. I'm sorry, nothing, I apologize.
Okay.
I withdraw.
I was about to ask, did we reach an endpoint regarding 340 and the photograph?
So the plan is to introduce the stipulated 340, which we'll get in, and then I will ask him if he can identify the photo. If he can't, he can't, but I'm going to try.
Okay.
And I'm not going to get into the substance of any of the bubbles, and I'm not going to introduce the bubbles or any of that.
Okay.
The only thing I'm going to display to the jury will be the picture on 340, and then I may have it side by side in front of O'Driscoll so he can compare and refresh on the one that's not getting introduced.
And to the extent you ask him about whether it was sent as part of text messages between
only the date.
Eric and Kouri on the date, it's a yes or no question?
Correct. Just
okay.
On the date, not the time, because I don't want to confuse anyone or require UTC time or any of that conversation. And the time really is irrelevant to us.
Okay. Mr. Bloodworth, anything further on that?
No, Your Honor.
All right. Are we ready for the jury?
Yes, Your Honor.
Ms. Nestor.
We are, Your Honor.
Dag, please.
2, 3.
Please have a seat as you come in. All right, have a seat. Thank you. Ladies and gentlemen, thank you for your patience. We will now proceed with additional cross-examination of Detective O'Driscoll by the defense. Detective, let's have you come in the courtroom. Detective, please step in front of Brittany and we'll get you sworn back in.
Do you solemnly swear the testimony you're about to give in the matter before the court to be the truth, the whole truth, and nothing but the truth, subject to the pains and penalties of perjury?
I do.
Thank you. Have a seat.
Exactly. Ms. Nestor, please proceed.
Thank you, Your Honor. May it please the court. Good morning, Detective O'Driscoll.
Good morning, Ms. Nestor.
I believe when we stopped yesterday, we were talking about the GIFs or GIFs. And I want to start by having you review a document that's been agreed to by the parties. It is exhibit number 3-40. And at this point, Your Honor, we're asking to admit it per stipulation of the parties.
So the witness can see 3-40. And do we want to publish now, counsel?
Please.
Mr. Bloodworth?
No objections.
State's exhibit 3-40 is admitted.
All right. And this was talked about when, I believe it was Mr. Kostradimos, I think, it's all blurring together now, was on the stand. But this is the group of all the GIFs or the GIFs that were in kind of a group and included the ones that were accessed on the morning after the police left Ms. Richins' home, after Mr. Richins passed. Do you remember the testimony about that?
Yes.
Okay. Can we go to the page that shows the GIFs in question? Maybe blow that up at the top. Okay. So I think that's two of them. One of them is from, I guess, the movie Dumb and Dumber. And the other one is our president. And I think there was a third one, but it's, yeah, Mr. Spacey and in a TV program, right? And those were the three GIFs that were talked about. And if you blow up the time that they were accessed, they all were accessed at 8:29:03 a.m. on March the 4th. That's the day that Mr. Richins was found deceased, correct?
Correct.
Right. And I know we've already heard the testimony that these are what we call orphaned GIFs. You can't really tell which text they came with and exactly when they were sent or who they were sent to or by. All we know is that they were somehow accessed at that point by her phone, correct?
That was the testimony, Mr. Kostradimos, yes.
Okay, can you pull up another one of the photos that is the picture from the house? That's it. All right. This is another picture that was accessed at that exact moment at 8:29. And can you blow the picture up a little bit? Do you recognize what that is, that photograph?
It's the legacy home.
It's the legacy home, right? And was there another photo that was accessed that same morning, also orphaned? Can you find that picture? It's right above it, I think. There we go. Can you blow that picture up a little bit? Thank you. All right. And is that also just a closer up view of the Legacy Mansion?
It appears so. It's very blurry on my screen.
It is. I think it is blurry. And then can you back out and show the time that one was accessed according to this same group of photos? That one appears to have been accessed at 10:42 a.m. the same morning.
That's what this document says, yes.
Okay. Now, if we could put just on the witness's screen, exhibit JO, I think it's 11, not for the publication yet, Your Honor.
Understood.
All right. And can you take just a moment and blow that up just a little bit so he can read it better? All right. Just take a second and scroll through that and tell me if that refreshes your recollection about any documents you reviewed about Eric's final communications before he passed.
Your Honor, objection. There's no foundation to get to whether or not his recollection requires refreshment.
Yeah, let's pause there. Would you lay a little bit of foundation before we get there?
Sure, and it requires us to go back to yesterday. So yesterday I had asked you right before we stopped if you had, as part of your investigation, reviewed the final communications of Eric right before he passed away, and you mentioned you had. Is that correct?
Yes.
All right. Based on that, if you could refresh, do you recall the communications you reviewed that day?
Not all of them. Some of them, yeah.
Can we then please blow up this document in front of him and see if this refreshes your recollection as to what you reviewed?
Mr. Bloodworth, the witness doesn't have it yet. Any objection to that question?
Your Honor, I think the objection foundation, I think there requires additional foundation.
I think the question pending is, are these among the things he reviewed, correct?
Maybe I misunderstood the pending.
Yeah.
That's the question.
So I think,
Can we back up a step? Maybe I'll catch up.
sure. Ms. Nestor, ask your last question one more time, please.
Are these texts that are before you part of what you reviewed from Eric's final communications on his phone?
Go one step before that. He hasn't seen these yet. He doesn't currently have them in front of him.
Do you recall all of the communications you saw that day when you were reviewing Eric's final communications?
All the texts from his phone?
Yes.
On the day before he died?
Yes.
I don't remember all of them. I remember some of them.
So then would you please look at this document and see if it refreshes your recollection and as to whether these were included in his communications?
Any objection, Mr. Bloodworth?
No, sir.
Okay. The witness can now see what you're referring to, Ms. Nestor.
Thank you, Your Honor. And can you go down just one more and maybe blow that up a little, that photo? Does this refresh your recollection, these communications of Eric's and Kouri's the day he died?
These are time-stamped March 3rd. That's not the day he died, but the day before he died.
Totally correct, because he died in, we think, the early morning hours of the 4th, right?
Yeah, he was pronounced deceased on the 4th.
Okay.
Yes,
So,
Your Honor. Sorry, objection. Foundation is to the meaning of died, right? He was pronounced dead on.
I think the witness and the questioning lawyer have a common understanding here. Overruled.
thank you, Your Honor. Okay, so were these included in what you reviewed in the communications between Eric and Kouri on the 3rd of March?
Yes.
All right. And this photograph, if you could blow that up.
Your Honor, objection. His recollection has been refreshed. I think the exhibit can now be set aside.
I'm not publishing it. I've just got one more question about the photo, and then I'm done.
I'll take it down and ask your question. If we need to refresh again, you can.
Okay, thank you.
Okay.
Wait, did you tell me I could ask the question?
Yeah, I took the photo down. Ask whatever you were about to
Yes,
ask.
yes.
Okay.
Does the photo that you just refreshed your recollection with match the same photo that we just saw in 340? That was the corner of the Midway Mansion.
Your Honor, the photo's still up on my screen, and the witness is
My apologies. There you go.
staring at it.
Sorry.
Ooh.
Is it the same photo, sir?
This one that we just saw that was enlarged, you're asking if that's the same as the one in the text message.
Does it match the one that we just put on the screen for the jurors that came with all those other pictures that morning?
Yes.
Thank you. That's all I have. Done with that. I'm sorry, maybe I'm not. Can I have just one moment, Your Honor?
Of course.
Okay. One more step. If we could go back to 340, which has been admitted, and pull up some additional gifts that were accessed at that same time. If we could pull those up, please.
Sure. There you go.
Okay, so there's the picture on the bottom left-hand corner of the Midway Mansion house, right?
Yes.
And that one was accessed at 10:42 a.m. the morning of the 4th?
Yes.
And the one with the champagne is also that exact same time?
Yes.
And the one with the farmer is that exact same time?
Yes.
And we know for sure that the one on the bottom left was sent the day before. Because we just looked at that, right? And you refreshed your recollection.
Yeah, I don't know if the part of the extraction that we're looking at right now is saying that that's where that came from. I don't know if that's the same file path, but that photo is the same.
Perfect, thank you. Okay, we can take that down now. All right, I also want to talk to you about, sorry, startle me. I also want to talk to you about the Google searches that were testified about here that were on Ms. Richins' phone or computer or both. Did you review those as part of your investigation?
Yes.
All right. And were you able to determine dates on all of those searches when they were made?
I don't believe so. Yeah, that would be a question for Mr. Kotradimos. I remember seeing the searches and the text of the searches, but I believe he testified that that there wasn't a timestamp associated with them and that they differed from the action in the phone that showed that a link was actually clicked on from one of those searches.
Okay, perfect.
And I believe those had timestamps.
Okay, the links, but maybe not the searches.
Correct.
Thank you for that clarification. And you agree that as of April the 13th of 2022, approximately a month and a few days after Eric passed away, that Ms. Richins' house was searched and she was detained in a police vehicle, right?
Objection, Your Honor.
Foundation.
Foundation, yeah.
Sustained. Lay a little foundation there.
Are you aware that there was a search conducted on her house on April 13th?
On Miss Richins' house?
Yes.
Yes.
And are you aware that while that search was being conducted, Ms. Richins was temporarily detained in a police vehicle for a period of time?
Objection, Your Honor, calls for a legal conclusion.
Overruled on that.
Go ahead.
I think the word detained is the problem there. I think there's been dispute over whether or not she was detained. But she was spoken to. She was asked to wait in law enforcement's vehicle until the lead detective could come speak to her about what was going on with the search.
Okay. So the searches on the website, fair to say that all of those searches are believed to have occurred after April 13th of 2022?
I don't know. Like I said, I don't know there were timestamps on the searches, so I can't be sure.
Did you ever interview any of Kouri's family or friends and ask them if they were responsible for any of those, or if they'd ever seen Kouri do it, or who did those searches?
No.
Okay. All right, I'd like to talk about the orange notebook for just a moment. We pulled up, do you have that orange notebook exhibit? I can't remember the number of it. court's indulgence for just a minute. I have the number. I've got it. I'll tell you. Just one moment. I'm sorry, Your Honor. It's hard to keep all these exhibits straight. Can we put up Exhibit 2-66R? It's admitted, Your Honor. Oh, wait, I'm sorry. Before we do that, can we put up Exhibit, 2-66R? That's correct. We don't have they redacted part of it, and we don't have that.
Scott, 2-66R, please.
Would he be so kind? I don't want to accidentally put something up that was redacted, Your Honor.
My apologies. We'll fix that. It's okay. One moment, please. Scott, if we do our normal dance, I'd appreciate it.
Yes. No problem, Your Honor.
Two 2-66R. Publish.
Yes, please, Your Honor.
There you go.
All right, and can we, that's what we like to call the orange notebook, right? Because it's like in an orange kids' school notebook, right?
Correct.
Okay, and can you fast forward, Katie, until I tell you to stop? Keep going. Keep going. Keep going. Keep going. Okay, right there. And can you blow out the bottom third of the page? All right, so this orange notebook that was recovered from the house, you don't have any knowledge about the circumstances under which it was prepared, do you? Or why it was written?
I do not.
And you don't know when it was written?
No, I don't.
And this was seized the day Ms. Richins was arrested, which was May 8th, 2023, correct?
I believe so, yeah.
So over a year after Eric's death, right?
Correct.
All right, and here on there is an entry that says on March the 22nd, can you highlight that please, Katie? Kouri starts counseling. Do you see that?
Mm-hmm.
You need to say yes.
Yes, sorry.
Did you take any steps to verify if that actually was the date she started doing mental health counseling?
I didn't learn anything about her counseling from interviews that we conducted. We did get Kouri's medical records, and I don't remember if a mental health counselor was part of those, but that's possible.
And I imagine as I forgot the word you used, as a serious crime investigator, homicide investigator, detective, death scene investigator, you've dealt with a lot of victims and family members who've been traumatized by a death and have required counseling. Is that fair?
My involvement with victims doesn't usually go that far to know whether they sought counseling or not. We refer them to the Victims Advocate Service, and they're much more equipped to help them with that.
Great. And have you ever heard of what's called trauma journaling?
No.
Do you know what that is?
No.
Okay.
Your Honor, maybe approach this.
I'll move on. I'm done with that. He doesn't know,
Are we
so I'll
approaching or
move
moving on?
Well, if we're moving on from the subject matter. No need to approach.
Got it.
on. We are moving on from the subject matter.
Very good.
All right. You also talked about the fact that you found it, I think you said suspicious, but I don't want to put that word in your mouth, but it was of significance to you that Carmen had placed Mr. Richins' obituary on her memory wall or her inspiration wall or whatever. Is that right?
I noticed it, yeah. I mean,
Okay.
it was something that caught my eye.
Did you happen to notice if there were any other obituaries right around it or next to it?
No, I didn't particularly notice.
Can we pull up exhibit? Yes, thank you. The second one, 816R, I think. Oh, it's 15? Okay, 815R. And that's in, Your Honor, if we could publish it.
I can't see it yet, Katie. Oh, you don't have it. My apologies.
Oh, that one's got things
Would
blurred.
you help us out? Thank you. Let's see. This is
Yeah.
8-15R. Let me just make sure this is the one you intended, Ms. Nestor.
That is the one.
And Judge, Katie does have this one if you wanted to switch back.
Okay.
Yeah, because I'm going to need her to blow it up. Can we switch it back to her, please? I'm so sorry.
No problem.
There was a recent version where they blurred a lot of children's faces out and stuff. Okay. Do you remember this picture we introduced of Mr. Richins' obituary on her memory wall?
Yes.
Can you please blow that up, Katie, to show what's right beside it or right under it? Do you see another in loving memory right below it?
Yeah, it looks like a program pamphlet from a funeral.
Okay. All right. Also, the C&E hat, I believe, that was on that wall that you noticed. Did you do any investigation to determine if Carmen actually, if Carmen actually did any work for C&E?
Yeah, based on our conversations, she never worked for C&E as a company. She did work on the Richins house. She interacted with Eric, but she was never employed by C&E.
Okay. All right. I also want to show you a text. As part of your investigation of reviewing texts between Eric and Kouri, Katie, if you could pull up Exhibit 2- I believe it's 2-3. Thank you. That's it. Before you look at that, do you recall trying to determine, investigating whether or not Kouri was aware prior to Eric's death that at least some, maybe not the house, but at least some of the assets that belonged to them or to Eric were shielded under some kind of a trust, if she was aware of that before he passed?
Yeah, that was part of our investigation.
All right. And did you review conversations she had with people about that and texts about that and things about that?
I didn't have any recorded conversations that she had had. I guess it depends on the timing that you're asking about.
Okay, I'd like to refresh your recollection and see if you look at these texts, if it reminds you if this is one of the things you looked at in trying to make that determination, okay?
Okay.
Can you blow that up? It's Exhibit 2-3D as in Delta. And just let him look at all of them, please, just slowly. Give him plenty of time to read. Can you go back up? I think we're missing that one. There you go, the next page. Does this refresh your recollection? Do you remember looking at this set of texts between Kouri and Eric?
No, I didn't have time to finish reading that.
Oh, sorry. Keep letting him read it.
Okay.
Does that refresh your recollection? Do you remember reviewing this series of texts between Kouri and Eric relating to the trust?
I don't remember, and the context of those messages, I can't say that that's what they're talking about.
Okay, so this does not refresh your recollection?
No.
Okay, court's indulgence for just one moment, Your Honor.
Your Honor, may I approach the state?
No, that's not true. It's hearsay.
I think in my response to her, like I said, these are hearsay were offered by you. But let me just look at my communications. I don't remember exactly which ones he asked for. If you want to ask that later, I just expect it. I know. 3,000 pieces.
All right, we'll just hold on.
Yeah. Can you please keep looking? I could circle back.
We're working on something, but I'm going to ask a couple more, move back, and then we may come back to it when she's done looking. So was it your understanding, without saying anything anyone told you, when you were conducting your investigation, did you become aware that Kouri knew of at least some portion of the some aspect of the trust being created before Eric passed?
Objection, Your Honor. More foundation, otherwise it's based on hearsay.
The foundation objection is sustained based upon the witness's prior answer. If you can start smaller, maybe build up to it, there may be some foundation here.
Did you interview people, look at documents, review texts to try to inform your investigation as to whether Kouri knew that Eric had created a trust for at least some portion of their assets prior to his death?
I reviewed information about the trust from several different sources. Everything that I reviewed suggested that she was not aware of how the trust worked or the consequences of the trust.
Totally fair. I think you're right about that. But was she aware that it existed?
Objection, Your Honor. Same foundation objection.
Overruled based upon his prior answer. You can answer, Detective.
I can't think of a specific instance, but I think there was some information that might have suggested that.
Okay, thank you. All right. Now I want to talk about Valentine's Day. You were here when Ms. Staking testified to the jury that in a conversation with a bunch of friends, there was some joking references made to Kouri wanting to poison Eric, and then Eric stating he had an allergic reaction and used an EpiPen. You heard that testimony, right?
Objection, Your Honor. Foundation. That's not what happened.
I think your recitation of Ms. Staking's testimony was correct until the last either sentence or clause.
Okay. Did you become aware that at least in some context there was a discussion about the Valentine's Day incident relating to Eric taking an EpiPen, using an EpiPen?
Ms. Staking, from my memory, testified that there was a comment made by Eric in a joking manner that Kouri had tried to poison him. And then she said that Kouri's explanation was that it was an allergic reaction.
And and that he used an EpiPen, right? Didn't she say that was the very last thing she said, I think?
I think so.
Okay, so did you do any investigation into whether or not Eric was treated regularly for allergies?
Yes.
And in fact, he had an allergy doctor, is that correct?
Yes.
And he had an EpiPen device in the master bathroom that was recovered during the first search.
Probably. I know that there were some located in the refrigerator on one of the searches. EpiPens, that is.
Did you ever investigate whether Eric discussed this allergic reaction with his doctor, his allergy doctor?
I believe one of our investigators contacted the allergy doctor and conducted an interview. I don't remember what the results or content of that interview was.
Did you determine what Eric was allergic to? Was he allergic to avocados or wheat or peanut oil? Do you know?
From what I remember being told by the investigator that had that conversation, it was like seasonal allergies, trees, grasses, dander, things like that.
Okay. Were you ever able to confirm that Eric ever sought any medical treatment for what allegedly happened to him on February 14th?
Just that in his text message, he mentioned that he might go to the hospital. So I don't know for sure if he did, but he was feeling bad enough that he thought he might need to.
Were you ever able to confirm that he did?
No.
Okay. All right, I want to also talk to you about Miss Susan Kohler. Do you know who Susan Kohler is?
Yes.
Who is Susan Kohler?
She's an associate of Carmen Lauber's. She worked for Doreen Kouri cleaning houses with Carmen Lauber.
Okay. And in the course of your investigation, what did you determine, if anything, was the role that Susan Kohler played with respect to this case?
We determined that she sold, I think the number was 15 to 20 Roxy's or prescription narcotic pain pills to Carmen at the request of Miss Richins.
Okay. And was Miss Susan Kohler offered immunity like Crozier and Carmen Lauber were?
Objection, Your Honor.
Do you know?
What's the basis of the objection, Mr. Bloodworth? Or do you need to approach?
Relevancy.
Approach for 1 second. The relevance objection is sustained. Ms. Nestor, please proceed.
Did you ever find any evidence or suggestion that anything Susan Kohler sold to Carmen Lauber contained fentanyl?
We found a bag of loose, I believe they were hydrocodone pills, in the mudroom walkway cabinet in the house. They were tested. They did not contain fentanyl.
Thank you. You also testified, I think, yesterday that shortly before Eric passed away, he went on a hunting trip to Mexico. We talked about that a little bit, right?
Mm-hmm. Yes.
Thank you. Was there any effort made to try to track Eric Richins' phone movements while he was in Mexico during that time period?
I don't believe we were able to get any kind of GPS location data from Eric's phone. I think the location data came from call detail records, as was demonstrated by Mr. Kotradimos.
And you also reviewed the phone calls. Well, strike that. I'll strike that, Your Honor. Okay, I think I'm almost done. If I can just confer with counsel, I'm going to wrap it up.
Anything else? Anything else?
All right, we're almost done. So just to recap a couple of days of testimony that got interrupted a lot. This investigation has now extended for a period of over 4 years, right?
Correct.
Okay. And during that 4 years period of time, as recently as less than a month ago, you were still issuing search warrants. Is that right?
Yes.
And there were a total of at least 10 searches by law enforcement of Ms. Richins' home. Is that right?
There were 10 search warrants issued, yeah.
And
Or around 10.
you heard that there's also at least 5 multi-day searches by a private investigator. Is that right?
I don't remember if it was 5 days. He said a couple days.
And the agencies that were involved in this case were the Summit County Sheriff, right?
Correct.
The Medical Examiner's Office.
They're not a law enforcement agency.
Well, they have investigator, right? She testified here.
Yeah.
Okay.
They're a civilian investigator.
Fair. Also, there was a private investigator that was involved in this case and communicated with you and provided information.
No, he was involved in the civil case.
Did he provide you information?
He provided our office information. I never talked to him personally.
All right. The DEA was involved in this case, at least briefly.
They never took any official action. Well, I should restate that. They assisted us with forensic tools,
Okay.
like call detail records and things like that.
Homeland Security agent, or I'm sorry, U.S. Postal Service agent was at one of the searches, right?
Yeah, I was aware of that.
We've heard, I believe that we're over 45 witnesses now in this trial. Is that right?
I haven't been counting.
And in all of that, we have no murder weapon. Like, you haven't found anything that was connected to Eric's death. No fentanyl in the house, correct?
There was a boatload of fentanyl in his stomach that came out of the house with him.
Other than this, what's in his stomach, did you find anything else that had fentanyl in it?
No.
Okay. You can't say how the fentanyl was administered, right?
Orally.
Besides orally.
That's all I know is that he took it orally.
We don't know exactly when it happened and what time of night or morning.
We know a time range.
Okay. You can't say the dosage that was ingested, right? 1 pill, 2 pill, 20 pills.
Illicit fentanyl does not come in dosages.
Okay. You can't say what was ingested on Valentine's Day at all, correct?
Fentanyl is definitely ingested. Oh, I'm sorry, on Valentine's Day.
Yes, on Valentine's Day.
No, we don't have any kind of medical examiner's report of his stomach contents from that day.
And on insurance fraud, we have not heard any testimony about any representations that Kouri Richins made to her insurance company, have we?
Objection, Your Honor.
If you put a word to it. Foundation.
Well, foundation also probably then hearsay.
Would you approach for 1 second?
I will.
State's objections are overruled. If you would restate that question, if you can, exactly.
I will. And we've not heard any testimony in this case about statements or representations Kouri made to her insurance company, correct?
Not statements. We've heard evidence about it.
Okay. And with respect to the forgery count, we've not heard any testimony one way or the other whether Eric gave Kouri permission to sign his name on documents, have we?
I don't think that's required to meet the forgery statute.
Have we heard anything about that? Do you know one way or the other whether Eric allowed Kouri to sign his name on documents as a married couple?
No, but that's still signing someone else's name, even if they give you permission, purporting it to be somebody else's signature.
Okay, well, the judge is going to instruct the jury on what the law is about that. But what I'm asking you is, as the investigator, do you have any knowledge one way or the other if Eric ever said to her, hey, it's okay with me, sign my name, I don't have time to deal with it?
I don't know.
And in fact, what we have heard is that he did give her at least one power of attorney at some point years ago, right?
Objection. Well, not objection. May we approach?
Sure.
Thank you.
And you were here when Mr. Throckmorton, the handwriting expert, testified, and you heard him say that he could not say that Kouri Richins was who signed that document. Did you hear him say that?
I heard him say that it was probably
not Eric.
Probably not Eric.
But he could not say that it was signed by Kouri, correct?
Correct.
Okay. I think that's it. I appreciate your patience. Thank you, Detective. Thank you, Your Honor. We tender the witness.
Mr. Bloodworth, within the scope of cross, please.
Detective O'Driscoll, in this case, are you the lead investigator among many investigators?
Yeah, it's a large team. I've had a lot of help.
Does your job in part involve coordinating the activities of all the other sheriff's office investigators?
Yes.
And are you the lead investigator for the sheriff's office as opposed to the county attorney's office?
Correct. I have no authority over what the prosecutor's investigator does.
And does the county's, well, you may have just answered this, but does the county attorney's office have its own investigation capability and authority?
Yes.
Is it your job as lead investigator to be omniscient regarding every investigative detail in this case, to include details of the county attorney's investigation?
No, I can't know every single detail. It's, as defense knows, terabytes of information.
And in early 2023, was your personal investigative focus on determining the source of the fentanyl that caused Eric Richins' death?
Yes, because like I said at the beginning, I came into the investigations division as a narcotics officer. Before I became the lead investigator on this case, that was our focus, is investigating drug-related crimes.
In early 2023, did the sheriff's office have a digital forensics capability even remotely close to the capabilities of Mr. Kotrodimos?
No, that's why we hired him.
And in early 2023, did the sheriff's office have any forensic accounting capability whatsoever?
In which year? Which date did you say?
Early 2023.
They had a little. I mean, how early? Not until March and April.
Well, let me ask you
January,
this.
0.
And any forensics accounting capability close to that of Brooke Carrington?
Oh, I'm sorry. Did you say forensic accounting?
Forensic accounting.
I'm sorry. I misheard. I thought you said digital forensics. No, the sheriff's office has no experts in forensic accounting.
And is part of the reason that they have no forensics accounting experts and minimal digital forensics experts because you have a small office, right?
Yeah, it's relatively small.
Did the county attorney's office become involved in this case in early May of 2023 when it charged Kouri Richins?
Yes, we only met with the prosecutors about a week before to give them our probable cause information.
Subsequent to charging Ms. Richins, did the county attorney's office engage Mr. Cochadimos and Ms. Carrington?
Yes.
And is Mr. Cochadimos the investigator who analyzed the digital forensics, including cell tower mapping and cell phone data?
Yes.
And was it Ms. Carrington that investigated and analyzed the forensic accounting, including the closing on the Midway mansion?
Yes.
And does the state provide the material from each of their investigations to the defense in discovery?
As far as I know, yes.
Do you recall in cross-examination when defense counsel picked a sentence from a May 2023 interview of Carmen Lauber, where it was either you or Detective Maynard told Carmen Lauber that she was something like the biggest piece of the puzzle?
Yes, I remember that.
What was the context of that comment?
She said something about, can we just lay out all the information, all the pieces in front of us? Because we were trying to establish a timeline. And we told her, you're the biggest piece. You're the biggest part of the information that we don't know. She had the information.
Sorry, I didn't mean to interrupt you. And did that context involve a piece of the drug purchase timeline rather than a piece of this whole giant case?
Correct. The timeline of her involvement, not necessarily the entire case.
And did that interview predate any information on the forensic accounting?
Yes.
And
We didn't even get into that until well after.
And did it predate any of Mr. Cochadimos' investigation?
Yes.
And did it predate your understanding of Kouri Richins' relationship with Josh Grossman?
Yes.
Do you recall whether that empty 2016 hydrocodone bottle that went with Eric Richins' body to the medical examiner's office, was discarded by the medical examiner's office in August of 2022?
Back to hearsay.
Please lay some foundation. Sustained.
Do you recall what happened with the empty 2016 hydrocodone bottle?
Need my objection.
Detective, it's a yes or no. Start there.
Yes.
How do you know what happened with the 2016 empty hydrocodone bottle?
I was told by other investigators that they're...
Objection.
Sustained on hearsay.
Did you or Detective Maynard give Carmen Lauber a ride to anywhere other than Wasatch County Drug Court or her attorney's office?
just here to this building.
To this building?
To
or
meet
this
with prosecutors or talk with her attorney. They're here.
Can investigators force anyone to speak with them if that person does not want to speak with them?
No.
Can investigators seize someone's cell phone without a warrant based upon probable cause?
No. It has to be consent or a warrant.
At any time, have you believed that the walk the dog letter gave you probable cause to seek a warrant to seize Ronald Darden's cell phone?
No, it didn't contain enough information for me to have gotten a warrant.
Did your investigation determine that the EpiPens recovered from the Richins home were for one of the Richins children?
Yes.
The GIF image, the one with Kevin Spacey that says, "Idiots, idiots everywhere." Is that from the TV show House of Cards?
From my understanding, yes.
Thank you.
I'm sorry, is he finished? We have no further questions, thank you.
May we release this witness?
Yes, Your Honor.
Mr. Bloodworth.
Yes, Your Honor.
Detective O'Driscoll, you are free to go. You are released from any subpoena.
Thank you.
Thank you, sir. Mr. Bloodworth.
Your Honor, the state has a stipulation to admit. I don't even think we have to publish it, so if the state could, I think we've marked it as 865. We'll admit that now.
Okay. Can I see it for a moment?
Your Honor, ma'am.
Please. Do you want me to give the Mujisik stipulation of fact preamble and read this to the jury? Or do you want to just admit it?
Your Honor, I think if we can just admit it now, during jury instructions, when the court would instruct on that, we can read this.
All right, we'll have a discussion about whether to convert this into a stipulation of fact instruction when the time comes.
Right.
Thank you, Your Honor.
Okay. State's Exhibit 8-65, titled Stipulation of Fact, is admitted by stipulation between the parties. Mr. Bloodworth.
Your Honor, state's in an interesting posture.
Do you need a moment on the record outside the presence of the jury?
We do.
Okay. I think this would be an appropriate time to just set a schedule for the rest of the day. Are we going to be able to, it seems likely to me, you tell me, that we'll be taking a recess now but not coming back for about 90 minutes. Does that sound about right?
Your Honor, that's my sense of it. I'm waiting on a defense decision.
Okay. Well, in either way, I'll bet you a steak dinner it's going to be about 90 minutes, but we're going to rise for the jury, and I'll send out word through the bail.
All rise for the jury. It's a lot of steaks.
We have lunch coming today, right? Okay, very good. That's fine. I just think they appreciate Ellie.
Yeah.
Have a seat, folks. Thank you.
I knew you were on it.
All right, Mr. Bloodworth, we're on the record. The jury is not present. Tell me what's up.
Your Honor, the state's waiting on the defense's decision regarding the Norris matter, because if they want to proceed in one fashion, the state will call some additional witnesses in its case in chief. If they want to proceed in another fashion, then the state will rest.
This is what I was trying to tease out, and I apologize for not being more specific. Given that they did not open the door to this issue through any of the state's witnesses in the state's case of chief so far, I understand the possible order of events from this point forward to be they'll make a decision about whether in the defense case to open the door to it. If they do, the state would be able to respond by, among other things, publishing evidence of Mr. Jeff's statements and, forgive me, the other gentleman?
Bonsavage.
Mr. Bonsavage's statements as part of the state's response to or rebuttal of the defense's theory of a failure or to investigate or incomplete investigation. But they haven't opened the door yet, so I don't think there's any need or ability for the state to get into it in its case in chief.
Okay, Your Honor, then the state rests.
Okay. With the state having rested, Ms. Nestor, does the defense have a motion?
We do, Your Honor. Mr. Ramos is going to take care of that.
Your Honor, under both Rule 17-0 as well as 77-17-13, discharge for insufficient evidence. The defense presents the following and moves for a directed verdict. At the conclusion, this is just for the record, Judge, as Your Honor knows, at the conclusion of the evidence by the prosecution, which has just been done, the court may issue an order dismissing any information or indictment or any count thereof upon the ground that the evidence is not legally sufficient to establish the offense or offenses charged therein or any lesser included offense. Judge, based on the evidence that has been presented over the past 10 days or so, including all inferences, of course, that can be reasonably drawn from the evidence, it is the position of the defense that some evidence exists from which a reasonable jury could find that some, however, not all of the elements of the crimes that have been proven beyond a reasonable doubt. In terms of the sufficiency of the evidence, Judge, I'll start backwards, starting with count 5. With regards to the forgery, even looking at all the inferences in favor of the state, we do not believe that the state has proven a specific intent to defraud as it relates to the forgery. There's no proof that the signature was done without Eric's authority. And even assuming that the defendant, Ms. Richins, signed on behalf of Eric with or without permission, that itself does not conclusively presume that because she signed the name of Eric that a forgery has occurred. The act, in other words, of signing another's name without permission doesn't constitute forgery, again, unless it was done with the intent to defraud, which we don't believe it has been met here. In terms of count 4, and forgive me, Judge, the way I'm approaching this is based primarily on the information, the criminal information, as the facts were laid out there. It was a bit difficult to follow through the testimony as to exactly what the state's position is. According to the criminal information, the basis for the true stage count 4 insurance fraud is that Ms. Richins, or rather True Stage left a voicemail with Ms. Richins requesting a copy of the prescription, any prescription Mr. Richins had for fentanyl. Then later that same day, Ms. Richins informed True Stage that fentanyl was not prescribed and that she had no idea how Eric obtained the fentanyl.
I think it's that last clause of that sentence that this is the state's prima facie showing. Do you see it differently?
And taking that as their basis, what the evidence has shown thus far has been that Ms. Richins sought and procured oxy from Ms. Lauber, that while Ms. Lauber indicated that it was fentanyl, her source, Mr. Crozier, provided fentanyl, that Mr. Crozier did not provide fentanyl. Rather, he provided prescription-grade oxy. From that moment, from the supplier, Mr. Crozier, to Ms. Lauber, the evidence is that what was provided was oxy.
May I ask you a direct question about that?
Sure.
Why couldn't a jury, properly instructed on the law and consistent with the court's duty when considering a motion for directed verdict, drawing all inferences in the state's favor, view the evidence as showing that Robert Crozier sold to Carmen Lauber 15 to 30 bluish pills marked M30. Carmen Lauber provided them to Kouri Richins, and then, based upon the testimony of Eric Haskell, that during that time frame, bluish pills marked M30 likely contained fentanyl.
Two responses. One, the testimony from Mr. Crozier as to the quantity and the amount per pill does not jive at all with the Haskell testimony as to how much fentanyl grade, or I guess street level non-prescription pills were going for. what was indicated in the evidence was the amount that was paid was consistent with prescription grade oxys. So that's how I would answer Your Honor's question.
Okay.
Count 3, as I understand it, is that Ms. Richins, again according to the criminal information, had indicated a phone number with an incorrect digit, the signature on the application that purported to be Mr. Richins is a forgery. We talked about count 5. And then in the context, and I think it was also the P.O. box. I imagine they were trying to establish that Mr. Richins didn't have access to that or something to that effect. I don't believe any evidence has been presented to that degree, or
The
that
P.O. box, circumstantial evidence that Eric didn't know about it.
not necessarily.
If I view the inferences in the light most favorable to the state.
And even with that, Judge, I mean, there was no evidence presented at all that from the Postal Service or anybody saying that Mr. Richins had no idea that that P.O. box existed. There was a statement and a question made by, I believe, the state, but no evidence was presented to show that that was actually the case. That's how I would answer Your Honor's question. Also, an interesting point. Term life insurance. At the moment that she allegedly signed on behalf of Eric and was submitted and was paid from her account, I am not certain that Your Honor could find that that term life insurance actually had value. What I mean by that is that there is case law, of course, in the civil process or context, that in the context of term life insurance, Utah courts have specifically addressed whether such policies have value as property. And the Court of Appeals in Beckham v. Beckham, I didn't write down the citation, I'll provide that, Your Honor, held that term life insurance policies generally have no cash value and therefore no property value. This is, of course, in the context of marital assets. So I bring that up. I think that's an interesting point. Obviously, it was marked for $100,000, but the actual value of that, I don't know, it raises an interesting issue.
Doesn't the statute talking about the elements of that particular crime for count 3 talk about property, money, or things obtained or sought to be obtained?
Correct. And that was going to be my last point, is at that moment, what the state needed to provide or prove, put forth evidence, is that at the moment that Ms. Richins allegedly signed on behalf of Mr. Richins for $100,000 term life insurance, that at that moment she knew that she was going to attempt to take her husband's life. And I don't believe they've met that, Judge. That's how I would answer that.
Okay.
With regards to count 2 and 1, most of these arguments overlap, but I will attempt to keep them separate, Judge. As I understand it, in order for them to have met the elements, in order for Ms. Richins to be found guilty of an attempt, she must engage in conduct constituting a substantial step towards the commission of the offense. Here, information has been, evidence has been presented that she did seek to obtain oxy. We've had that discussion. Obtaining that oxy, just obtaining the oxy itself, is mere preparation. There is case law, as I'm sure Your Honor is aware, in State v. Johnson, 821 P2D 1150, that indicates that that is not enough. coupled with the information that we just discussed as to whether it was oxy, whether it was fentanyl, I believe that's even Ms. Richins' case currently is even in a better posture than Ms. Johnson. So with that, if we look at it in the context of the Valentine's Day, there is no evidence at this point that what was obtained was fentanyl, one. Even if it was oxy and she sought to obtain that, beyond that, there's nothing else, no other evidence that indicates that Ms. Richins took those pills, the greenish blue ones, I think at that time 15 milligrams is what Mr. Crozier said, and did anything else with it. I think the evidence as to Mr. Richins ingesting a sandwich is clear in terms of Ms. Richins picking it up. Absolutely. That his reaction was a result of that and not anything else. I believe that the evidence is scant. Your Honor has a question.
No, I'm following you.
I will say that even in the Johnson case, the evidence was clear that the defendant in that case had actually obtained a specific type of drug, methamphetamine. So even in that case, they knew exactly what was obtained. Here, it's unclear what was obtained. I will add this before I forget. It relates to all of this in your prior question. In terms of the pills, Ms. Lauber testified the amount of pills that was significantly different from what Mr. Crozier had indicated, as well as the packaging. I believe that's important in the court's consideration in terms of what type of pills ultimately were given from Mr. Crozier to Ms. Lauber. This same argument, not to rehash it, applies to count one. And it leaves us with the administering of the drug. Zero evidence has been presented besides that fentanyl was in his system, in his gastric, and it was possibly orally ingested. There has been no evidence in terms of the administering of whatever it was at all. Judge, for those reasons, the defense requests that Your Honor exercise your duty under both the Rule 17 as well as the Code, and we move for directed verdict on those counts, Judge, for those reasons, unless Your Honor has any questions.
I do not. You'll get the last word.
Thank you.
Your Honor, can I perhaps begin by asking the court if the court has any particular element that they would like the state to speak on?
No, I understand the standard. I believe I understand the state's theory on each of the counts, especially 1, 2, 3, and 4. Speak to count 5 if you want to. Specifically, Mr. Ramos's argument regarding lack of believable evidence regarding intent to defraud.
Your Honor, it ties into count 3, right? It's the same insurance. This is the $100,000 true stage policy. And the scheme charge, the scheme fraud in count 3 is that Kouri Richins, at the time she took out that $100,000. Well, this is interesting. The timing doesn't matter for count 3, but the timing does matter for count 5. That as it relates to count 5, at the time she forged Eric Richins' signature, she intended to
the fraud. I think the evidence that supports her intent is the fact that nothing on the face of the application indicates that Eric would know of this application, right? The mailing address, the email address, the phone number, everything, the payment, everything comes back to Kouri Richins. And she signed this, I think it was late January 2023, at a time when she had...
January 29, 2022, correct?
I'm sorry, 2022. It was the end of January 2022, at a time when she had already begun asking Hayden Jeffs and Carmen Lauber for drugs of some sort, at a time when she had already expressed her interest in starting a fresh life with Josh Grossman, and at a time when she had told Becky Lloyd that she would be better off if Eric was dead, and at a time when she had told Josh Grossman if he would just go away. So there is sufficient evidence in the light most favorable to the state that a reasonable jury could find that on January the 29th, when she forged Eric Richins' name, she had intended the entire fraud scheme that's charged in count 3.
Understood. Anything further?
No, Your Honor.
Okay.
Thank you.
Mr. Ramos, anything further, sir?
Just briefly, and this is, of course, if Mr. Bloodworth wants to respond to this, I did neglect in my argument initially as to count 2 the testimony regarding the joking nature conversation that Ms. Stakings had that she testified to with both Ms. Richins and Mr. Eric Richins. Of course, Your Honor heard that, so I would just add that for the record.
Understood.
Thank you.
Thank you. Mr. Bloodworth, anything further?
No, Your Honor.
All right, folks. I appreciate the argument. This is an important motion. Let me just take 5 minutes to collect my thoughts, and I'll give you a ruling. We'll be in recess until 5 of noon. Thank you.
All right.
All right, so, he's taking a 5-minute break? Wow, he's only taking a very short break. I was behind a little bit, like 5 minutes, but I think I caught up. All right, so they're arguing directed verdict, judgment of acquittal. Well, directed verdict, they're calling it here. Mr. Ramos went through all 5 counts, but he really laid out, he really laid out the forgery, insurance fraud, and with count 2, which is, I guess I'm not sure which count is count 2. I know she's got 1 count of aggravated, 1 count of attempted, which would have been the Valentine's Day one, 2 counts of insurance fraud, and then 1 count of forgery. So he talked more on the forgery and the insurance fraud than he did with the aggravated. But it was interesting. He said, Mr. Ramos said, Kouri did seek to obtain oxy, so they're conceding that, and he's even conceding that's preparation, but he's saying that's not enough to show that she then would have had the intent to go ahead and give that to her husband. So I thought that was interesting. So this empty hydrocodone bottle, it was from 2016. It seems like that came from a knee surgery. So there was nothing else was found in the house. The only, I thought that was pretty interesting. Detective O'Driscoll was like, well, there was a boatload of of fent found in Eric's stomach as he was taken from the house. I thought that was an interesting, jab back at Miss Nestor. So, so they're still not sure if. So here's the rub. Remember from this morning, defense may want to bring in some information that then the state will have to bring in a couple more witnesses, at least 3 more witnesses. So the state is still waiting on the defense to talk to Kouri and talk amongst themselves whether they're going to bring in this David Norris call. He apparently called law enforcement, said, hey, Eric talked about fent, tried to ask me about it back in 2019, and they have to decide if they're going to bring that in or not. All right, let's see. We have 626 people watching and 90 likes. If you guys don't mind, just take a moment and hit the like button. That is much appreciated. For those listening, please just take a moment and hit the like button. Would really appreciate that. And all right, so the defense still has to decide if they're going to bring in this David Norris call to law enforcement, because that's going to open up the door for the state to bring in Nick Von Savage, his call, his inmate call, or call with another inmate about Carmen had enough money from making sales from fentanyl. Who else? It was the Hayden Jeff's conversation with his sister. So they would bring that in. So they would bring in, who would be the third one? Nick Von Savage, Hayden Jeffs, and so much has happened. I'm trying to remember what happened this morning. Nick Von Savage, Hayden Jeffs. Who is the third person? Let me see here. I'm forgetting now. Like I said, so much has happened. So Von Savage, I think maybe that's it. But they said they'd bring in 3 more witnesses, so I can only get Hayden Jeffs and Nick Von Savage. I guess that's it. Okay, I guess that's it. So the defense still has to figure out if they're going to bring in David Norris. And the state says they vetted him, law enforcement interviewed him. There's, I think, 2 affidavits. I think an interview, and what else? What else was? So the state would call in their investigator and would add 3 more witnesses. So this really, really is a big moment here. The state would not rest if the defense is going to call in David Norris, if they plan on calling him in. So they would call in at least 4 more. And the judge said, hey, if I allow Norris's statement to come in, then I need to allow the state to admit evidence from Hayden Jeffs and Von Savage. So. All right, guys. Oh, thanks. We went up to 128 likes. Awesome. So they did rest, but I heard him say, yes, we do rest, but I thought it still had to do with, are they going to bring in, he did say, okay, then we do rest, but and then they were going to do a judgment of acquittal. But I thought this defense still had to decide. I thought the defense still needs time to decide. All right, here we go.
Okay, we're back on the record in case 231-500-139. Counsel for the state are present, counsel for defendant and the defendant are present. The issue before the court is defendant's motion for a directed verdict, seeking dismissal of counts 1 through 5 in the operative information. It has long been established that the elements needed to make out a cause of action may be proven by direct and by circumstantial evidence. And if there is any evidence, however slight or circumstantial, which tends to show guilt of the crime charged or any of its degrees, it is the trial court's duty to submit the case to the jury. When evaluating a motion for directed verdict, the court is not free to weigh the evidence and thus invade the province of the jury, whose prerogative it is to judge the facts. Rather, the court's role is to determine whether the state has produced believable evidence on each element of the crimes from which a jury, acting reasonably, could convict the defendant. Not will, not would, but could. Moreover, the evidence must be viewed in the light most favorable to the state. Applying these legal principles as announced by the Utah Supreme Court in State versus Montoya, 2004, UT 5. The court finds that the state has established a prima facie case against defendant Kouri Richins by producing believable evidence of each element of each crime charged in the operative information. Defendant's motion for directed verdict is respectfully denied. Ms. Nestor, you asked for time to speak with your client to make some strategic decisions. Is between now and 1 p.m. sufficient time?
Yes, Your Honor.
Okay. Mr. Bloodworth, anything further before we recess until 1 o'clock?
Nothing further, Your Honor.
Ms. Nestor?
No, sir.
All right. We'll be in recess until 1 p.m., just confirming that to the extent the defendant will be putting on evidence or calling witnesses, you have a couple in the wings. Is that correct?
Yes, sir.
Okay. 1 p.m. Thank you for your time. Court's in recess.
All right, so court is in recess, and I have some things to do here. We're going to do some kitty cam for you guys, but hold on a sec. I've got some things I have to do. Because we lost our internet, I had to blow up my system back here, so I have to redo everything. Hold on a sec. This will take some time, so let me get some music up for you guys before, and I'll do kitty cam for you guys. Let's see here. Sorry, guys. I'm trying to find my music. Just bear with me. Oh, here, I guess I can do this. All right. Nope, that's too small. All right, you guys are going to see this in real time. All right, so in any event, we'll do that. We'll do that. Let's see. Yep, you guys are getting a peek behind the curtain here. There we go. All right, we'll start with that. See, I seem to think I have to fix. All right, now let me see if I can get my music going here again. Let's see here. All right. All right, we'll take it from there. See you guys in a little bit.
bakabaka b'omu gye by'oyagala bikolebwe mu nsi nga bwe bikolebwa mu ggulu olw'emmere yaffe ey'olwaleero tusonyiwa okwolona kwaffe nga bwe tusonyiwa abatukola obubi.
All right, welcome back, everybody. Got a few minutes here, 7 minutes before the top of the hour. 7 more minutes until court is live. Thought I would just come back in. Checking on you guys, see how everybody's doing. How was your lunch break? We thought about bringing you a kitty cam, but they're mostly sleeping. Roger's over here, he's passed out. He looks like a little shrimp. Houdini and Riker are kind of floating around doing something, I think it's Sid. Anyway, some of them are awake, some of them are sleepy, so. Thank you, Elaine. Thank you. Welcome back to you as well. Let's see, Sharon, if she's not guilty, why does Kouri have to tell Bro what to say? Why wouldn't his truth be the same without the letter? Well, if you believe what Kouri says, that was just a manuscript. That was just fictional. So she wasn't telling Ronnie what to say per se. She's writing a fictional story. So we have to get over that hurdle first. See, JMS says, we know the defense will call witnesses. The big question is, will Kouri testify? I think she needs to testify, especially if Ronnie is not testifying. Either way, she is going down. All right, widespread. Am I muted? Am I muted? It says, we know the defense will call witnesses. Nope, I'm not muted. Elaine, have to say you have good choice in music. Thank you. Aaron comes up with the playlists, so I will pass that sentiment on to Aaron. Aaron is my better half, and Trial TV Live. Whenever you see Trial TV Live posting comments and posts, that's Aaron. She does tons of work on the back end. She makes all the shorts. She does the playlists. So I will pass on your sentiment to her. The fiction versus was follow on to its lawyer client and other mutually contradictory explanations. Yeah. Oh, I'm sorry. The fiction version was a follow-on to its lawyer, client, and other mutually contradictory explanations. Yeah, she's kind of moving the goalposts, right? Heidi says the shorts are great. JMS says great music, Aaron. Sparkling Princess. Aaron makes great tracks every trial. Picks perfect songs. Brown Eyed Girl says love the music. Sherry says it really is. Yeah, thanks, guys. I think the only soundtrack I made was the New Year's Day. I think I did the New Year's Day one. But yes, Aaron does a great job with the music for sure. Hi, Squid Kid. That's really funny you mentioned them because they hit my algorithm last night and I couldn't get enough of them. I could not get enough of them, but yeah, that's really funny. All of a sudden, this band is like in my algorithm, and I'm trying to figure out how and why. To me, they're very Pink Floyd, like early Floyd, like 69, 70, 71 Floyd. That's what I'm getting. I have to hear more of them. I listened to about 2 or 3 songs yesterday, and to me, I heard a lot of early Pink Floyd. And see, here comes Aaron. That's available to our members. Yes, all of our soundtracks are available to our members. So if you are a member, you can go check them out. Sparkling Princess, the New Year's Eve or New Year's Day one, yeah, it was real chill. It was chill, real lo-fi, downbeat. Miss Justice, does Anton, does anyone know why Sky left Kouri? Yes, irreconcilable differences. Kouri was trashing her. Sky was part of a firm The firm of Ray, Quinley, Nebeker claimed their desire to stop defending Richins stems from the civil cases the firm represented Richins for, not the criminal one. Whatever the issues were, they were connected to the entire firm, so the firm as a whole asked the judge to find another defense team for Richins' criminal trial. In recent released court filings, Richins had disparaging things to say about her lead attorney, Sky Lazaro, at one point. During a video conversation, Richins reportedly called Lazaro a dumb expletive, and family members said Lazaro's ego was taking over. So then there's that, plus it's reported that Kouri asked Sky Lazaro to bring her crest whitening strips, and that would have been contraband. So, Miss Justice, I hope that answers your question. Brett says also the fiction version asserts that the prosecution had read an entire 65-page story. Absolutely nothing supports that other than her own statement to her brother. Bassist is so good. Love seeing female musicians in good bands. Yes. Did Kouri win her civil cases, or are they still going on, Mama C? They're still going on. They have not been completed yet. Sherry, a quick side note: Mr. Bloodworth and his wife have been married 28 years and have 2 children. Nice. Wizard of Ezzy says, normally a firm can do a Chinese screen, but I have a feeling Sky wanted off the criminal trial altogether. What is a criminal screen? Now you're going to make me look that up. I'm sorry, Chinese screen. What's a Chinese screen? I need to look that up. Oh, that. Wait. Oh, are you? Wait. Is that's got to be... It's not literal. I'm assuming you're not being literal. You're being esoterical on that. Jane, David Norris was somebody apparently that had a conversation with Eric back in 2019 about fent. And then he called on the defense's urging, as we found out, he called the defense and the defense urged him to call law enforcement. So he had a conversation with Eric in 2019 about Eric wanting or buying fent. Let me see if I can find the exact wording. 2019 encounter he had with Eric where Eric asked if David had any fent. Eric gave him a check for work done. So it seems like David worked for Eric because Eric paid him with a check. So David and Eric apparently asked him if he had any fent. The reference is building a virtual... Okay, thank you. The reference is to building a virtual wall where the case is one side. The case is one side and the conflicted attorneys are on the other side, and never the twain shall meet. Okay, that's what I figured. That's what I kind of figured. After I saw, wait a minute, it's like a Japanese screen, Chinese screen, a room divider. I gotcha. So it's like an esoterical thing. Gotcha. Just mentioned Kouri was saying things about Sky. Yes. You're welcome, Jane. Yeah, there was a conflict. Kouri apparently said that Sky had a... What did I just say? She had an ego. She called her I think she called her a bad word. She called her a dumb, Family member said Lazaro's ego was taking over. I also understood that Kouri asked Sky to bring in some teeth whitening strips. So, Sparkling Princess. It's possible Sky could have gotten her off. So kind of good, she left. But still, Sky seems like a good lawyer. Yeah, I would have. It would have been really interesting to see where we would stand at. Where would we be right now? Here, I can take my scroller off. Where would we be right now if Sky was on this trial? Was on this case, I should say. at this trial, huh? Right? Where would we be? Exactly. Yeah, she called her a. Rhymes with which, probably. Let's see. Bama, honestly, if I looked at Sky and I was as smart as Sky, and I would more than likely have an ego too. Welcome back, Widespread. Welcome back. And Wizard says, and Kouri said that Sky would be fine with sneaking contraband in the jail. Yeah. Miss Justice, would Sky be allowed to say something negative that happened with Kouri or just a conflict? Probably would say just a conflict. I don't think they're going to get down in the weeds or down in the mud. I don't think lawyers would. Well, at least I would hope that lawyers would not do that. Never police. Oh, comfortably numb. All right, looks like we got court coming back. Let me turn this up a little bit.
In 231-500-139. State's counsel and defense counsel are present. Ms. Richins is present. Mr. Bloodworth, would you like me just to tell the jury when they come back in that the state has rested?
Yeah, so that's fine.
Okay, will do. Ms. Lewis, Ms. Nestor, what's the plan?
Ready to go.
Who's defense counsel's first witness?
Can we have just a minute?
Yeah.
We have a couple of options.
Understood.
You don't want to. Your Honor, actually at this time, the defense intends to rest.
We should probably do that in front of the jury, yes?
Right?
Okay.
I agree.
I just want to make sure you've consulted with your client about this.
Absolutely.
Is now an appropriate time to get a waiver of Ms. Richins' right to testify on the record?
Yes. Yes, you can.
Okay. You've consulted with Ms. Richins about her, or advised Ms. Richins about her right to testify, correct?
At length.
Okay. Ms. Richins, may I ask you two direct questions?
Yes.
Do you understand that you have the right to testify at trial?
Yes, I do.
Are you following your attorney's advice and waiving your right to testify at trial?
Yes, I am.
I accept your waiver. I find it's knowing and voluntary.
Yeah.
Okay, thank you. Anything further on the record, Ms. Lewis?
No, Your Honor.
Mr. Bloodworth, how would you propose we proceed from here for the rest of today?
So let me backtrack a little bit on your earlier question. I think I should then rest in front of the jury.
Understood.
The defense can then rest in front of the jury. I think then for the rest of today, and I propose tomorrow, the court recess, and that we begin. The parties can work on jury instructions perhaps today or tomorrow, but then we instruct and close on Monday.
My face is not telegraphing any opinion one way or the other. I'm just waiting for a response.
I don't think we have a problem with that. I thought we were thinking it might make sense to get the jury instruction conference out of the way, and then.
I agree with you. May we do it tomorrow? Give the counsel, both sides, a chance to talk to each other about any additional instructions you think might be necessary, narrow any differences or discuss any differences you have regarding any of those, and we can have that conference tomorrow.
Yeah. Yes, that's fine.
Okay. So we'll talk about scheduling about that. Just want to make sure we're all comfortable with the jury being out in the wild between now and Monday morning. Yes?
Yes.
Yes, sir.
Okay. Okay. All right. Are we ready for the jury? Mr. Bloodworth?
Yes, sir.
Ms. Lewis?
Yes, sir.
Okay.
All rise for the jury.
Please have a seat as you come in. Have a seat. Thank you. Mr. Bloodworth.
Your Honor, the state rests its case.
Very good. Ms. Lewis.
Your Honor, after consulting with our client, the defense rests.
Understood. Thank you. Ladies and gentlemen, there is some legal work that I need to do with counsel in this case to get from here to the next stage. Rather than use your time inefficiently with you in the courtroom, we're going to do the following. We're going to recess for today. You will be on your own in the wild between now and 8:30 a.m. on Monday morning. I cannot emphasize this enough. Between now and 8:30 a.m. on Monday morning, please do not say anything about this case to anyone. I would understand if you had to tell somebody that you have to be back here at 8:30 a.m. on Monday morning. Other than that circumstance, please do not discuss this case with anyone. Do not allow anyone to attempt to talk to you about it. It will take affirmative effort and diligence. I need you to use that same affirmative effort and diligence to make sure you avoid watching, listening, or reading anything about this case from any source whatsoever. And please do not do any search, research, query, anything of any kind between now and 8:30 a.m. on Monday morning. Please travel safe. Enjoy your weekend. I'll see you at 8:30 a.m. on Monday. Please rise for the jury. All right, folks, have a seat. May I propose the following? That counsel have an email exchange or a phone call, say 4 p.m.-ish today, about the state of the jury instructions and whether you think there need to be any additions or amendments. And then, to the extent there are, please send me an email or file something in the docket and let me know that you did. And then what time would you like to get together to talk about the instructions one by one tomorrow?
9:30?
Do you want to do it a little later just so I have time to look at whatever happens?
You suggest?
Late as possible.
You want to do it at 1?
Yes.
Sure.
Mr. Bloodworth?
Sure, sir.
All right. So you're all at least going to compare notes by the end of the day today. And if you file anything additional, you'll let me know by email. And I'll plan on being back on the record with you all 1 p.m. tomorrow. Mr. Bloodworth, anything else today?
No, Your Honor.
Ms. Lewis?
No, Your Honor.
Okay. Ms. Richins, 1 p.m. tomorrow. The court is in recess. Thank you. All rise.
All right, so wow, what a turn of events. What a turn of events. So they will be coming back tomorrow. The jury won't be, but the parties will be coming back tomorrow to discuss jury instructions. So we're going to at least get that. Yeah, Sparkling Princess. That was not expecting that. Was not expecting that. I just want to make sure. Okay. All right. Let me just collect my thoughts here. All right. So the state rested. We had pretty firm grasp that they were going to do that, but it was going to be up in the air to see what the defense was going to do with this David Norris, combining names here. David Norris, the defense was still up in the air whether they were going to call him or open that door. So the state said, hey, we'll rest if they don't do that. If they don't, then we're going to have to call 3-4 more witnesses. So as it turned out, the state talked with the defense, the state rested, and the defense decided then they wanted to rest as well. They said they had 3 witnesses ready to go today. Yesterday, they said they have 3 witnesses ready for today. This morning, they said, yep, we have those witnesses ready to go. As even 20 minutes ago, they said, yep, we have witnesses ready to go. We are ready to go. And apparently, they spoke with Kouri and they decided, they decided that they're not going to put on a defense. All right, so we're going to have Selena call in. So if you guys hang tight, we're going to have Selena K is going to give us a call. And I have questions. I have questions for Selena. So don't go anywhere. We have Selena K in the courtroom. She's going to be joining us. So let me just kind of wrap my head around what's going on here. So the defense asked for a directed verdict. That got denied. Then backing up from that, we had Detective O'Driscoll was back on the stand for cross. And then before that, we had the defense arguing that they wanted to bring in testimony about this David Norris and question Detective O'Driscoll about certain things. That's what this morning was all about. Wow, just these last couple of days have just been, my brain is trying to sort through all of this. All right. This morning kind of did seem like it was all for naught. It did kind of seem like it was all for naught. Heidi, who would be reliable enough to testify? Maybe some experts, maybe a doctor, maybe some of her friends. I was thinking maybe some of her brother, maybe her brother. That's why we had that poll. Yeah, we even took a poll. Who is most likely? Rob, her brother, 53% of you. Kouri, 27%. David Norris, 13%, and her brother DJ, 7%. We heard a lot about Rob or Robbie. We heard DJ's name. We heard Mom's name. I took Mom off because we had that on the earlier one before we lost our internet. I did not put her back on because she's in the courtroom, so she does not get to testify. Yeah. So this whole thing about this morning, just throw it out the window. This whole thing with David Norris, throw it out the window. Can this add to the appellate situation? Pammy, that's up to an appellate lawyer. I guess anything could sort of fall under appeals, but that's why Judge had Kouri stand up and said, "Are you sure you want to do this? You don't have to do it. I mean, you don't have to testify, but know your rights. Are you of sound mind and body? Are you under any influence of anything?" Elaine, mind-blowing is the word, right? Lori, roller coaster trial. Jeff, I'd like to hear about the jury's reactions. Sparkling, I can't see her wanting to put her brother up after the letter. Kathy, I do believe this will make for a shorter verdict. Paula, trials are always wild, but this one was wild. Joanne, I hope to never watch another case with these defense attorneys. I will refuse to waste my time and energy. JMS reminds me of the Brian Walsh case. Remember, they said they would put a case on 2 and then at the last minute rested. Yeah, I do. I remember that. Brad, apparently none of the above would have been the right choice. Miss Justice, yeah, well, we're going to have Selena Kay is going to call in. So if you want to hear from inside the courtroom, stick around. Wizard, I sort of saw this coming earlier that there would be a Walsh move. Carol, the jury has to be shocked. Elizabeth, do we know if anyone in Kouri's family believes she is innocent? I think they all do. To be quite honest, I think her mom does. I know Ronnie does. I'm thinking they all do. C. Gilmore, I don't think even Netflix would touch this one. In their openings, 2, which is huge. Let's see, I missed that. She said he said that he would take the stand. For Brian Walsh. Yeah. Laura, yep, we're gonna ask Selena. I don't know if she's gonna call into Scott. She might call into Scott first. She may call into Scott first. So we'll just hang here until Selena calls in. I hope Selena has seen some jury faces when it was announced. Lazy Boys, Ronnie told the media that she was innocent. Yeah, Sparkling Princess, yep. I literally gasped. I was like, whoa. My gob was smacked. Widespread, I don't know if they believe she's innocent. I think they're just on Kouri's side no matter what. Oh, her family. Lisa, I thought I heard once that family members were allowed to be in the courtroom even prior to testifying. Am I dreaming? No, you have to be. You can be a party. You can be a victim, like Elisa Mathewson. So if you're a victim, you can be in the courtroom and you can testify. If you're the lead detective, I should say, you can be in the courtroom. You can sit at the side of the state. We've seen that in Lori Daybell. We've seen that Chad Daybell. We've seen that with Jodi Arias. We saw that here with Kouri Richins. We've seen that in a lot of cases where the lead detective will sit at the state's prosecutor's table, and then they'll get up and they'll testify. But if you're just a regular person, no, after you testify, you can sit in the courtroom, as we saw with Katie. but you can't because you could alter your testimony. You could alter your testimony based on what you're witnessing. Your testimony could be altered. Your perception, even if you're the most truthful person in the world, your perception could be altered by something that happened 3-4 years ago by listening to other people's testimony. See, Butterfly, does this mean we will get a verdict soonish? Well, we have to do jury instructions, the charging conference, so that's going to be tomorrow. So 1 o'clock, 3 o'clock Eastern, 1 o'clock local time, so Mountain Time. So we'll be back tomorrow, and we'll go through that, and then what's today? Thursday. So that's Friday, and then they're coming back Monday. And then they're going to do closing arguments and then jury instructions. I'm not sure which order yet. They have to figure out which order. And then deliberation. So a verdict probably will be next week. I don't know when. We can take polls. We'll set up a poll on Monday how long we think the jury will deliberate for. I would think I've been so off, to be quite honest. I've been so off on predicting verdicts. I'm going to go, okay, my prediction is going to be, I thought Colin Gray was going to be like 2 days, and they came back in less than 2 hours. So, and there's only 5 charges, so it's not like they have a lot of. I like to hear the jury instructions before I pick how long it's going to take, because that if there's like 5 pages of jury instructions versus 20 pages in verdict form, that makes a big difference. But then look at Colin Gray. He had like 29 charges. I thought it would take him at least 2 hours, 3 hours to go through the charges and the verdict form, and they came back in less than 2 hours. So. Man, I don't know. This one's tough. I don't see this as a slam dunk, to be quite honest, you guys. I don't see this as a slam dunk for all charges. I'm not seeing this as a slam dunk for all charges. Let me just put it that way. Kimbers, you too? Yeah, wait for the jury instructions. Downey Lynn, yeah, Colin Gray was fast. Valerie, isn't it guilty if it's a fast verdict? Generally, yeah, we've seen some very, very fast verdicts that have been guilty. That is true. I'm trying to think of a case where it's been a quick not guilty. An hour to discuss and 1 to fill out paperwork. Carol, what's our next trial you'll be covering? This could be done by Tuesday. You're right. This very well could be. Well, our next big one, actually, we're going to find out tomorrow what our next big one is. But right now it's looking like Julio Fulio, which I love saying his name. Charles Jones out of Tampa. He's a rapper. It has to do with factions, 2 factions that don't get along with each other out of Jacksonville. So that's the one we have our eye on. Missy, well, I come back from working a bit and I missed everything. Renee, but they said they were going to take 5 days. What happened? Kouri changed her mind, maybe? Pammy is not interested in Fulio. All right, Pammy, we'll see you at the next trial then. You don't have to watch. That's cool. Lori, yes, been seeing PI Sam. Yeah, we'll know tomorrow a lot more about that. Yeah, if you guys don't want to join us for Fulio, no problem. We understand. We'll see you at the next trial. But we're going to cover it because Florida PI Sam is going to be there. She's defending one of the defendants. So we're going to cover it. If you guys don't want to watch it, that's more than your. Well, of course it's your right. You can do whatever the fuck you want. So anyway, what else? Yeah, Courtney Clenny is at the end of April. We are going to cover Courtney for sure. All right, we're just waiting for Selena to call in. I think she's probably calling Scott. Here we go. Hello there. How are you?
Hey, oh my gosh.
Yeah, what happened?
Are you guys as shocked as I am?
We are. What the last couple of days have just been incredible.
You could have I think my mouth dropped open. I'll have to go back and look at when I get home because I felt it, I'm like, I did not see that coming, not at all.
I know. Well, tell us give us your impressions. What happened? Or give us your impressions from inside the courtroom.
Well, what was so weird is like the defense, whether this was a tactic to make the prosecutor think that they were going to put on a case, they had the mom step out like she might be the first witness, Kouri's mom. Mm-hmm. And then so the prosecution rested, and then the judge said to him, is it okay if I just tell the jury you've rested? So he said yes until the defense did that, and then he wanted to say it in front of the jury. But so right minutes before they rested, they're whispering with each other. They're like, we have a couple options. I don't know if you've caught that. I'm like, oh my gosh, what? Are they deciding which witness to call first or whatever? Right. You could have just heard a pin drop in there when they said they arrest.
Yeah. Well, yesterday they said they had 3 witnesses. I think even today they had 3 witnesses queued up. And then even like right before they said they rested, it seemed like they were ready to call witnesses. They had multiple witnesses that they kept under subpoena. And we thought for sure that they'd call at least 2. Well, the 3 that they said that they had queued up, and then when they said nope, we rest, I was shocked. I was really shocked. How did the jury?
I can read the chat. I'm shocked with all of you. I'm my head's still spinning. Because Miss Nestor was like, "Are you ready?" When the judge asked, "Yep, we're ready to go," and I'm like. What the heck? So, closing arguments are going to be critical in this, I believe, on Monday.
Mm-hmm. Yeah.
You should have seen the jury's face. They were shocked as well. They were like deer in the headlights. And then a few of them started smiling when they heard they were going to be off until Monday.
Mm-hmm. Wow. Well, again, throughout the entire trial, we kept hearing the defense say, yep, we're going to keep them subject to recall. We're going to keep them under subpoena. And that's what the jury heard. But then a lot of times we heard the jury was out of the room and they were saying, yes, we plan on calling these 3 witnesses, at least 3 witnesses.
Right.
And we're trying to figure out who could they have called. We did a poll. We thought maybe Ronnie, because we heard a lot about Brother Ronnie. We heard about Brother DJ. We thought maybe Mom, but Mom's been in there the entire time, so she can't testify if she's sitting there through the entire time.
Now, I don't know if you noticed, I think it was when the financial expert was on for the prosecution, mm-hmm. There was a man sitting with Kouri's family who was their financial expert, and he listened to all of her testimony. He was blonde and had a suit on.
Yes.
Was sitting, and so they at one point thought about calling him, but they called no one. I don't know what to say.
I know. It's so weird. And then the whole finagling back and forth with. Yesterday it started with bringing in Detective O'Driscoll's testimony. Remember, they argued back and forth about that. Or was that like 2 days ago? I feel like I'm in Twilight Zone. I can't even get my days straight.
That was yesterday morning, wasn't it? Yeah.
Well, I know they sent the jury home. Today's Thursday, so was it Monday they sent the jury home after? Like they argued for like hours, and then they sent the jury home.
It was. Yeah, you're
Monday.
Right.
And then Tuesday. Again, my days, I'm getting my days mixed. Well, I can look at my, that's why I take notes. Okay, so then
that's good.
Yeah, then they brought Kouri Richins back in on the 10th. Then they brought in, then they brought Carmen in. That's right. Then they brought Carmen back in, and she was only on for like 10 minutes. and then that's when O'Driscoll came on. So they were arguing about what they were going to allow Driscoll to say, what evidence they were going to bring in. And then when he actually, okay, I have to ask you, because I've been talking with our chat a lot about this. How did he come across in the courtroom as a witness in the sense of his knowledge of the case? Like, what was your perception on that?
Oh my goodness, horrible. I would give him a D for being the lead detective. There was so much he didn't know. And I was baffled at that. Okay. You know, I've never seen a lead detective not be on the stand longer either, you know?
Yeah.
I mean, he was only on the stand a couple hours. I was expecting we might get to defense on or to get his cross maybe Friday, right? But there was so much that he was asked about that he didn't know. And so that's what I'm kind of like, I'm on the, right now I'm saying, no, not guilty. There's too much reasonable doubt of what I've listened to and watched over the last 15 days. But, oh gosh, he just wasn't confident. He just was wish-washy and just not great. Not a great look for the detective.
Okay. Good, because that was my perception too. I heard a lot of I don't knows. That was somebody else that did that investigation. I wasn't a part of that. I don't recall. I don't remember.
Exactly.
Yeah.
And Chris, don't you think he was supposed to? Usually, their strongest witness, the lead detective.
Yeah.
Do you think that's why the defense? I kind of just had this thought pop into my head. Well, maybe that's why they decided to arrest, because he was so not effective in my mind.
Yeah.
And when he was on the stand, he didn't have the jury's attention like some of the other witnesses.
Interesting. So were they watching him? Were their eyes kind of wandering around, or what?
They were wandering around. Some of them were looking in the gallery. Some of them were, just like not checked in like they have been on other witnesses.
Yeah.
Yesterday, during the cross of Nestor, which I think she kicked butt on, they were tuned into that, and they were writing tons of notes. And that is the most engaged I've seen with him being on the stand. So
interesting.
Yeah.
Interesting. All right, let's see what else. There was a lot of legal wrangling going on. A lot of sidebars, and of course we can't hear the sidebars, but when the jury was out, before they would come in, I mean, there was a lot of fantastic back and forth. I feel like I went through at least a week's worth of law school there during the course of this trial.
Me too, right? We're all smarter.
Right. How do you think the judge came across being in the courtroom? Do you think he had a handle on the defense? Do you think they got away with too much? Were they like, what do you think from that standpoint?
I think this judge is my favorite judge I've ever watched so far. I think he was very, very fair, like when he went out this morning and tried to make a remedy to what, was going on with all the legal about the man that had called in, and the police didn't investigate it. That's the thing, Chris. The investigation was so lacking of being complete.
Yeah.
If somebody calls in and says, Eric called me to buy fentanyl, you would at least look into that, right? They didn't even look into that dude.
Well, Mr. Bloodworth said they did. They said they have, I think, 2 affidavits. They have interviews, and I think Mr. Bloodworth said that they did vet him, that they did. So did that come across in court or no? Because I have that in my notes.
Well, the detective didn't do any. The detective, I don't know. You might have heard something I didn't, because the detective on the stand, when she questioned him about that, said he had not. They have not followed up with him. No one called him back. Nobody took it serious. He called in 3 different times So maybe that came in when you weren't seeing that. I don't know, but that did. They didn't even check into him.
Okay. Yeah, it was Mr. Bloodworth saying that when the jury was out. So that was not O'Driscoll's testimony. That was Bloodworth saying, yeah, no, we've already vetted him, and to us it's a nothing burger. I can't remember if so. You remember Miss Nestor asking Detective O'Driscoll? Okay, I don't quite remember that.
Well, this morning, she that was what all that long argument was about. Is that, and she just like, I think it's not fair to my client to not get to just bring this up that he was not even that scenario of how Eric might have died was not even looked into, you know?
Yeah. What did you think about her ending with Detective O'Driscoll on the stand when she went? Did you find after all the 10 searches, that you did? He's like, well, there were 10 warrants, there weren't 10 searches, and I wasn't a part of any of them. But she kind of went through. You don't know if Eric gave Kouri the authority to sign his name. You don't know how the fentanyl got in Eric's body. You don't know that Eric gave Kouri power of attorney. So she kind of was going through all this list of things, and I thought, what'd you think about that? Do you think he held his own with that, or do you think he was kind of squirming under that as well?
I think he was squirming. You should, yeah. You get to feel the vibes in the courtroom where you don't on TV. Mm-hmm. Yeah, he was squirming every time she was questioning him because everything she said was like a failure that he had not. Yeah. And this is a small area. It's not like this is a big city where they have a lot of crime. Mm-hmm. So to not be able to do a real thorough police investigation, it's bogus. Mm-hmm. So
yeah, that's it's interesting. I was looking forward to a defense because
me too.
Yeah. Because so you said you have reasonable doubt. Are those on all 5 charges? Because we have fraud.
No.
We've got aggravated.
No, let me clarify that.
Yeah.
Okay.
Okay.
The financial charges and the forgery. The only one I have reasonable doubt on is the murder.
Now, what about the attempted, the Valentine's Day?
Same. Those two.
Okay. All right, but the fraud and the forgery, you think she's guilty? You think they showed?
Correct.
They proved?
Yeah.
Okay.
Oh, yeah. They had evidence enough for that.
Yeah.
Any of the financial crimes are, I think it was when I called RA. It's like she is kind of a snake in the grass of all the crap she's pulled, and we got to hear, but that in my mind they have not proven that she gave him the fatal dose of fentanyl. It's just. The state did not prove that to me, and so I'm not guilty on those two. So.
Okay. I agree with you on the insurance fraud and the forgery. I think they pretty much proved that. The attempted on February Valentine's Day, that one I would have reasonable doubt. But the March 4th, the night of the celebratory Moscow Mule, that whole thing, I go back to. So there's 3 scenarios, right? There's Eric did it on purpose, so he took his own life. He accidentally did it. He didn't realize he was doing it, so he accidentally did it, or somebody else did it, right? So there's no evidence whatsoever that he wanted to take his own life, right? We can agree
I think
on
that was totally not right. Even in the game plan. That came up, but I don't. Yeah, I didn't give that any thought.
Yeah, he loved his kids. There was no record, no evidence that he was
very successful in his business. There'd been no, so.
Right, so we can throw that out. Okay, so then the next scenario possibility is it was accidental. So but there's no traces of gummy THC in his system, and we know that lasts for like 30 days, give or take, a couple days here or there, whatever. So that means he did not do anything. He didn't smoke or didn't do gummies for at least a month. So how else would he have gotten fentanyl in his system accidentally then?
I don't think he did. I think he took pain medication what really sealed my reasonable doubt thing, which I already had it, was when they started talking about him going to Mexico on that hunting trip. And I think he was doing the medication. I think a lot of the medication that she was purchasing was for his bad back, but he had pain. And I just think in Mexico, unfortunately, I think he got something that was laced with fentanyl. So, because remember, Chris, they said he had Googled about how far it was to drive back to that same place in Mexico.
Yes. Yeah, like Sedona, something like that.
So why would he be wanting to drive there? I mean, that's another, it is just full of reasonable doubt in my mind, but
no,
I know
fair. That's fair.
It's only my opinion. I don't want to, I'm just saying from what I be honest, like when I walked into the opening statements on Monday, I was so on the guilty train. Yeah. But I have had to be really hyper focused listening to the evidence, because you can do nothing else in here but sit. You can't breathe, you can't smile, you can't, so Monday I walked out on a totally different mindset.
Interesting. Yeah.
So
interesting. I think I'm only on the fence with the Valentine's Day. I go just to, I said it yesterday with the, Occam's razor, and Wizard said it as well today just now, the simplest solution. So the kids didn't do it. They didn't have a party where somebody slipped Eric this lethal dose. He didn't do it. So the only other two options then is that Kouri did it, or you're saying that Eric bought some pills and those were laced. Is that where you're going? That's your theory?
Yes.
Right.
And the testimony that they didn't let come in today was he had called that man looking for fentanyl, and that was not allowed to come in to the jury. But that had happened, and he had called the police. Like I said, I'm repeating myself, but 3 times. So there was some evidence. There was a little bit of evidence that he had some, addiction, some reasons to take the medicine.
Well, he had knee surgery in 2016, right? That's what the bottle, what's a hydrocodone, I think. Yeah, I always get those mixed up. Whatever. He had, but it was from 2016 for knee surgery. So there was no evidence, though, that he was contacting anybody via phone.
Well, just the one man. There was. He called into the police 3 times, and then.
Oh, Norris. That's the David Norris guy. David Norris.
Right.
Yeah.
Right. David Norris. David Norris. Yeah. And then, his hunting trip was not. I can't remember how long they said it was before his death, but it wasn't really that long. And in the walk the dog letter, which is I don't know what you believe on that, but she claimed that he kept them in his work truck in an allergy pill bottle. So they would have not found any in the home. I mean, it's just a crazy case. This trial has had so much.
Yeah. I thought at the beginning of it, I came in, like you said, pretty much guilty, and I think I'm leaving it pretty much guilty as well. But I also came in like I had high hopes for it. We watched all these pretrial hearings. We've been on it for like years. I was really looking forward to it. And then with all the sidebars and the objections, and it's like stop, start, stop, start. I felt like I'm like every time it kind of picked up some momentum, it was like it got jerked off the rails. But now looking back on it, I'm like, wow, this was a really interesting trial. Very interesting trial.
It was very interesting, and more so than I thought, because I was like you, from all that we've heard all these years, I thought, well, it's just going to be a cut and dried, slam dunk for the prosecution, which we have seen trials do be that way. Yeah. But it is not. It's not been that way at all. So anyway, I'm coming up Monday, and I am going to be hanging out until they tell us the jury's gone home or we have a verdict. So
Okay.
I can text you when I know one way or the other if you want me to.
Oh, absolutely. Yeah, please do. Please do, for sure. Yeah.
All right.
All right, we'll let you go. Thank you so much for calling and being there, and drive safely. I know you have a long drive home, so be safe.
Okay, thanks.
Okay,
Bye,
see you.
everyone.
Okay, take
Thank
care.
you, Chris.
Thank you.
See ya.
Yep.
Bye.
Bye. All right. So thank you again, Selena, for being in the courtroom and for calling us. Really appreciate that. Let's see. Shirley, she will be found guilty on at least 3 of the 4 charges. Yeah. So she's got 1 count of aggravated, which is March 4th, 1 count of attempted aggravated, which is the Valentine's Day, February 14th, 2 counts of insurance fraud, and the 1 count of forgery. So we'll do a poll because we'll stay on for just a little bit longer, but we'll start a poll on Monday. No, actually, maybe tomorrow, because tomorrow we'll be on at 3 o'clock. Well, maybe we'll go on earlier. We have to figure out what we're going to do tomorrow as far as the stream. But we know for sure that court will be in session tomorrow at 3 Eastern, 1 o'clock Mountain, which is local time. So we will definitely be there. So we'll do a poll. Let's see, Wizard, what do you say? Let me see if I can grab that. Where are you? I'm trying to find you here, Wizard. Why is it not coming up? All right, I'll just read it over here. 1 of the 2 pills of fent would not produce 5 times the lethal dose unless they were horse-sized pills. Yeah. Did they? They did not have a doctor on, right? They did not. Now that I'm looking back, the state did not call a producer of, like, a medical doctor. They just had medical examiners. They had a couple autopsy assistants, and the medical examiner testified, yes. Would that have made a difference? Would it have made a difference if like a engineer or a scientist, a chemist had come in that worked for GlaxoSmithKline or Pfizer or whoever and said, yeah, to have 5 times the amount of that, legally, you would have had to have 20 patches on yourself, or you would have had to take in 30 pills, or, legally. So I guess that's the point, is that it was illegal. I guess that was the point of the defense, is that this was illegal. So, yeah, they just had the ME. There was no confirmation, and even she couldn't figure out how much he took. So it would have been all illegal. So let's see, Cola Claymaker rewatch his sister in the Emmy. Yeah, I think we'll do that tomorrow. We'll do. We'll do tomorrow. Tomorrow's Friday, obviously, and they're going to go on at 3 our time. So we'll come on at like 9, I guess 9:30, whatever, and we'll do some rewatching. How about that? We'll do some rewatching. Carla, yeah, to explain how it all breaks down and all that. I would have liked to have seen that. If I could have asked for anybody else to testify, it would have been nice to have a chemist to come in and kind of explain that. Wizard says, even street fent would have been so many street pills. Yeah, they would have been knocking back a lot of pills. Right? Yeah. Yeah, Cola. No, we'll do some rewatching tomorrow. I think we'll do some rewatching tomorrow. All right, does that sound like a good idea, you guys? Looks like Jenny, you guys like it. Pammy, yeah, what a trial. I'm telling you, this was I came into it with such high hopes. I think I even told you guys that on day 1. Because remember, we were finishing up Colin Gray, and I'm like, we were doing Kouri at night, Kouri after dark, after hours. And we were crashing and burning there for the first couple of days. And I was getting really frustrated. I'll be honest with you guys, I was getting really frustrated. I'm like, I wanted to just scream, because a like a lot of trials just go really smoothly, and this trial was just like herky jerky and back and forth and sidebars and objections. Like literally, some testimony was like a sentence came out, objection, sentence came out, objection, and I was getting really frustrated by that, you know, and then it kind of fell into a little bit of a groove, and then it still fits and starts, stops and stop and go. It's like being in stop and go traffic, right? And stop and go traffic at 90 miles an hour. And but now that I look back on it, I'm like, this was quite a trial. This is definitely quite a trial. I think because I had high hopes. Is that the right phrase? You know, I guess I did have high hopes only because I did so much backstory on it, and it didn't start out the way I was anticipating it, meaning just smooth and witnesses come up, you know, Cross is really, you know, cutting and gets in there. And now I look back on it, and it definitely was a very interesting trial. Lots of behind the scenes look on how, you know, how lawyers, you know, argue their words, literally words, you know, not just a concept or a phrase or a sentence, but like literally a comma, you know, and I find that fascinating. So, yes, Fanny saying, thank you, Selena, for being there. All right, let's see here. Sharon, definitely not what you expected. Lazy boys are going to take off. All right, have a good one. There you go. See you later. Hey, Mona, we should have a celebratory gummy that we don't have to listen to any more Cross. Sherry, you still think she's guilty? Fair enough. We'll do a poll. We'll get a poll up tomorrow. We'll have a couple polls. One will be, you know, is she guilty on such and such charges? And then Monday we can do how long will the jury take to deliberate. We'll definitely do that. Kim says Kouri's definitely guilty. That walk the dog letter shows her intentions. Sharon, defense started crazy, ended the same way. I'm not gonna argue with that. The defense was out there. That is for sure. Let's see. Care Bear, you're still with guilty, but it's sounding like jury might be split and judge will declare mistrial. It would not surprise me. To be quite honest, you guys, at this point, nothing's going to surprise me. Nothing's going to surprise me that comes out of this trial. She's found not guilty on all 5 charges. I'd be like, you know, it's not. They could be split. They could find her guilty on the forgery and the insurance, and not guilty on the aggravated part. They could find her innocent on the insurance and the forgery and guilty on the aggravated part and the attempted. Who knows? I'm not. Nothing is going to surprise me with this. I have been surprised before. Trust me, I have been surprised before. Carla, lots of forensics were missing too. Widespread's giving out free gummies. All right, Elaine, signing off. Take care. Thank you. All right. Be safe, be well. All right, it's 4 o'clock here on the East Coast. I think we can, we'll probably say goodbye as well. A quick programming note. Live trial starts tomorrow at 3, and it's going to be, they're going to go over jury instructions. So we will do, we'll recap. We'll recap the trial. Instead of just the week, we'll just recap the trial, and we'll pull like some interesting testimony from each day, because we have, in earnest, we have, well, it was 13 days long, but really nothing. Well, we had Cross from O'Driscoll, but we'll pull. I'll maybe not from every day. Let me just see. I'll talk to Aaron about this tonight. We'll figure out what like the best, because we'll have like 3 hours. I'm sorry, we'll have about 6 hours to go through. So we'll figure out which 4 or 5 witnesses we can pull out. So we'll do that for you guys tomorrow. So all right, with that, you guys, I will leave you with Super Bowl over there. I got little Ginger over here. Thank you for spending your day with us. Really appreciate it. Thank you to our mods for keeping our space a nice, safe space for you guys to express your opinions. and be kind and courteous to each other. Really appreciate our mods. Thank you, huge thank you to Aaron. When we lost our feed because our internet just decided to drop out for a minute there, we scrambled and we got the second feed up and running for you guys. So thank you to Aaron for that. Thank you. She makes a bunch of shorts. If you guys haven't checked out her shorts that she is making, definitely please do so. Please hit the like button on the way out. We have 204 likes. Really appreciate that. Yeah, we'll see you guys. We'll see you guys tomorrow at. I'll call it now. We'll say around 9 o'clock. We'll say 9 o'clock Eastern. So until then, be well, be safe, take care of yourselves, and we will see you then. Bye.